Oblige.
I put the appellant.
Mr.
T. Taggu.
Land Council for Land Council appearing on behalf of Mr. You are appearing on behalf of Mr.
L. Perme.
He is there. His name is there.
No, his name is not there.
His name is also not there. Then
My name is there. T. Taggu, my name is.
T. Taggu.
Yes.
Mr. T. Taggu, Land Council for the appellant. Who is for the other side? Is there any private?
State.
Private is also there.
Private is not there, madam. State is there.
Okay. Yes. Okay. Praise for adjournment of the matter for
3 weeks.
3 weeks.
Yes.
To which Mr. Yete Lana Edison PP has no objection. They are allowed. List this matter after 3 weeks. Okay.
My lord, I beg to mention item number 18, my lord. It's a criminal misapplication for cancellation of bail, my lord. So basically, your lordship, it was filed that the condition imposed by the
As an instruction to withdraw this criminal misapplication, to which the Lana Council for the respondent has now objection. Yes, triggered. This criminal misapplication is dismissed on withdrawal.
oblige, my lord.
May I, my lord, with the consent from other side, I beg to mention item number 27. Of K lawyer for the respondent.
For respondent.
Yes.
And who is for the appellant? Have you informed?
Yes, I have taken consent.
Mr.
P. Harming.
Your name is not there.
No. I'm appearing on behalf of K lawyer.
Mr. D.
P. Harming.
P. Harming.
Yes, my lord.
Lana Council appearing on behalf of Mr. K lawyer, Lana Council for the respondent. This is a private respondent.
Yes, my lord.
Private respondent with the consent of the Land Council for the appellant. Case for adjournment of the matter for
3 weeks, my
3
lord.
weeks. The prayer is allowed. List this matter after 3 weeks.
Deeply obliged.
May I please?
List after 3 weeks, Lord.
Have you informed the?
Yes, I have taken consent from other side.
You are Mr.
G. Tai, Lord.
G.
Tai.
Tai. Your name is also there?
Yes.
Land Council for the petitioner. As for welfare. Petitioner summary states the conducting council, Mr. K. Lowland, Land Council for the petitioner, would not appear today due to his personal difficulties. Therefore, praise for adjournment for
3 weeks, Lord.
3 weeks, to which Mr. Yete, Lana Edison PP, has no objection. Edison PP for the.
In item number 10 and 11, my lord. In item number 10 and 11, state is there. 9, your lordship, state is not there.
9 is not there.
Yes, your lordship. 9 is.
9 is also criminal petition.
Yes, your lordship. It's standing counsel for the GST, my lord. GST.
Okay, this is the. This is matter after 2 weeks. In which item there is interim?
11, Lord.
11. Okay, in 10 and 11. Earlier one, Mr. Sanchez, son Mr. Yellow Line is due to personal difficulties. Prayer not objected by the additional people. According to the prayer is allowed, list this matter after 3 weeks. Stop. Para. The interim order passed earlier shall continue till the next date of listing.
Oblige, your lordship.
And again, Lordship, item number 26, Lordship.
Item
26, Lordship. I am for the respondent, Lordship. I have taken
then there
consent
will
from
not be
petition.
the hearing list. Okay, you are for
Respondent, Lordship. All the respondent.
respondent.
Yes, Lordship.
Have you informed the
Yes, I have taken consent from applicant, Lordship.
Mr.
G type, Lordship.
G. Tai, land council for the respondent number,
All the respondent, Lordship.
land council for the respondents.
May I, Lords? Lordship, I beg to mention item number 7 for adjournment. I'm appearing on behalf of Mr. T. Tofu for the petitioner, Your Honors. Lordship, so leading counsel is out of station due to a health issue. So, Lordship, matter may be adjourned. Matter may be listed after 2 weeks.
You are for
Respondent, your lordship. Your
Private.
lordship. Your sorry, your lordship.
private respondent?
Yes, your lordship. The second
Okay.
respondent.
No,
Your-
objection.
No objection. Your lordship, if it can be listed after 1 week.
After a week.
1 week, yes, your lordship.
Mr.
Oh, Tita Kyang?
Itakia.
Yes,
Submitted.
Lordship.
The conducting counsel, Mr. T. Tofu, land counsel for the petitioner, is out of station. Therefore, pray for adjournment of the matter for a week, to which Mr.
VT Gurum.
T.
Gurum.
Your name is there.
In Wakalat Nama, yes, your lordship. I'm on behalf of G. Talo.
Appearing on behalf of Mr. G. Talo, land counsel for the respondent, has no objection. Accordingly, the prayer is allowed. List this matter after a week. Okay.
Machaulay.
Yeah, please.
Hmm.
I would like to mention item number 16,
Item
number 16. Here I am the petitioner. This matter become intrusted during the pendency of this petition. The trial court has already returned the accused person from charges. So I would like to withdraw this petition.
okay, Miss
Permit.
A. Parme, land counsel for the petitioner, submits that during the pendency of this criminal petition, the trial court has already acquitted the accused,
Discharge.
discharged the accused, and thus the matter has become fructuous. Stop, huh? Paragraph. In view of the above, this criminal petition stands disposed of and stands closed on becoming infructuous. Okay.
My lordship, I beg to mention item number 6. I'm for the petition. The petitioner.
Okay, have you informed the petition?
Yes, yes, my lordship.
Okay. You are Miss,
M. Jarang?
your name is there,
No, my lordship.
appearing on behalf of Mr. R.
R.
Sana,
Sana.
Land Council for the petitioner, with the consent of the Land Council of the respondent, pray for adjournment of the matter to be listed after
3 weeks.
3 weeks. Adjournment of the matter for 3 weeks. The prayer with this matter after 3 weeks. Okay.
My lordship, I also have to mention item number 22, which is list for order. And for the respondent number 1, I have to file IA, for which I need some time.
Wait for some time for that. We'll see what for it has been listed. We'll see. Okay.
Okay,
The
my
office note and pass over. Grant adjournment. Okay.
May I please, Lordship? Lordship, I beg to mention item number 17. I'm appearing on behalf of Mr.
Which one?
Item number 17.
Item 17.
Yes, your Lordship.
This is in order. We'll see and pass over necessary. Okay, wait for some time. Okay. Are you in urgent?
Lordship, actually, the conducting counsel is out of station.
Okay, we'll adjourn, but let us see the office note. What for it has been listed. Okay, wait for some time. Yes.
Your Lordship, I beg to mention item number 14.
14 also in, is not, but for it has been listed, okay, we'll pass necessary.
All right.
Ma'am, before coming to the grounds on which the impugned cognizance order and the consequential summons issued by the learned Chief Judicial Magistrate Alo have been challenged. I would like to draw the kind attention of this honorable court to the two provisions of BNSS, madam, which are relevant for the purpose of adjudication of this revision.
This is for revision
Yes, ma'am.
against the order passed by,
Against the cognizance order dated 28/3/2025, passed by learned Chief Judicial Magistrate Alo.
Okay.
My lord, may kindly have section 2H of the BNSS. I'll draw the kind attention to explain.
explanation of the complaint.
Yes, madam. May I read?
Okay,
A report made by a police officer in a case which discloses after investigation the commission of a non-cognizable offence shall be deemed to be a complaint, and the police officer by whom such a report is made shall be deemed to be the complainant. Now, my lord, may kindly come to section 223. madam. Section 223 is part of 16 of BNSS, which deals with the trial of complaint case.
section 2.
23. madam. May I read?
Complaint to magistrate.
Yes, ma'am. A magistrate having jurisdiction while taking cognizance of an offence on complaint shall examine upon oath the complainant and the witness present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witness and also by the magistrate. First proviso is important, madam. I am concerned with this particular proviso. Provided that no cognizance of an offence shall be taken by magistrate without giving the accused an opportunity of being heard. Now, madam, under the old act, there was no provision for hearing the accused at a pre-cognizance stage. Now, this right has been incorporated by the first proviso. Now, coming to the facts of the case, madam, on 30/3/2024, an FIR was registered against the present petitioners on the basis of a complaint lodged by the respondent numbers 224 before the Alo police station. This FIR was registered as Alo PS case number 19 of 2024 under section 324 and 34 of IPC. That FIR, my lord, will find at page number 20.
Okay.
So, after completion of investigation, my lord, the investigating officer laid charge sheet under section 323 and 34 of IPC. Section 323 is not. Now, my lord, though the charge sheet is dated 16/5/2024, but the charge sheet was filed before the learned trial court on 31/2025. This date, my lord, I have ascertained through my personal inquiry, because I do not have any documents to substantiate this date, my lord, but I have mentioned this date in paragraph 6 and 9 of the revision petition. Since the charge sheet is subsequent to the coming into force of BNSS, BNSS, my lord, came into force on 1st of July 2024. Therefore, my lord, charge sheet in the present case discloses commission of non-cognizable offences. In terms of explanation to 2H, same shall be deemed as a complaint, and the police officer who submitted the charge sheet shall be deemed to be the complainant.
Same order was passed by the trial court.
Trial court passed the order on 28/5/2025.
No, same order.
Sorry, ma'am.
Same order, same deem.
Yes,
yes.
yes. But, hello, cognizance of the offence under section 323
circumstances here in this case,
Yes.
it's not a complaint case straight away, but then initially it was filed before the
Yes.
police. Okay. So whether the examination of the or giving an opportunity
That is
to the
correct.
complainant
That
is
is correct.
necessary here in this case.
Yes, ma'am. Because that is this statutory requirement under first proviso to subsection 1 of section 323. madam.
Because it was filed, this was filed
After coming into force
after
of
coming course of the BNSS.
BNS,
So according to you, it was filed only after.
only after. It was
So
filed on
The record, sorry, as per the police, it was filed earlier.
no, madam. The charge sheet is dated 16/4/2024, but there's no, there's no cover letter wherein the date of filing of the charge sheet before the learner trial court can be ascertained. Through my personal inquiry, madam, I have ascertained the date on which it was filed before the learner trial court. Date is 30th of January 2025.
No, by this 2H,
Yes,
only the police officer
madam.
is to be shall be deemed to be the complainant.
Complainant.
So whom to examine? Now,
Examination of the police officer is not required as per. subsequent-
now the original complainant,
No,
original informant need to be examined according
No,
to
madam.
you.
Before that, madam, before taking cognizance, madam.
Yeah, that is what I'm saying. Before taking cognizance,
Yes.
according to you, the original informant need to be examined.
No, madam. Since the complainant in this case, in terms of explanation to 2H, is the police officer, my lord.
Hmm.
Under subsection 2 of 223, my lord, since charge sheet has been submitted in discharge of public duty, therefore his examination is not required.
Not required.
Not required.
Okay.
My lord, can I come?
Examination of the complainant is not required.
Not required.
Okay, then what is your grievance then?
My lord, the first proviso
Hmm.
to section 223 provides that no magistrate shall take cognizance of an offence without giving an opportunity of hearing to the accused person. This right,
Without
giving
giving-
an opportunity of hearing to the accused person. My lord, may I kindly come to 223.
Are you for the accused or for the informant?
For the accused.
You are for the accused?
Yes, ma'am.
I thought you are for the complainant.
No, my lord. I'm aggrieved by impugn order by which cognizance is taken
Okay.
without giving an opportunity of hearing to me.
So you are not satisfied with the reduction of the from 24 to 23.
Sorry, my lord.
So initially it was, and
Yes.
initially it was registered under 224.
Yes.
Sorry, 324.
324.
Now it is brought down to 323.
Yes.
You are not satisfied with that, and you want you to be examined also.
My lord, because that is the
Okay,
mandate
just a
of
minute,
the first
just a minute,
proviso.
then, I thought that you are for the informant, initial informant. Provided that- Okay, yes.
Yes, my lord. The procedure expect your lordship, I will clarify everything, my lord. Now it is well settled. There is no more res intriga by the Supreme Court also, your lordship.
Hmm.
Your lordship, so far as the IO will become a complainant. So once statute says IO become a complainant, immediately, your lordship, we have to refer to the chapter 16 of the BNSS. Now, I will come to that with the judgment also. Your lordship has rightly pointed out one thing, your lordship. For complainant, there is no any requirement of examination because he is an official complainant, or he is official witness. For others, informant, your lordship, their statement is required to be recorded on oath before taking cognizance. For the purpose of taking cognizance, on oath, their statement has to be recorded. I will come to that again, your lordship. The Kerala High Court has delineated the procedure in complaint case.
Now, despite this has come from the.
Yes, my lord.
Okay.
When it get the cloth of complaint, my lord, then immediately we have to follow the procedure of the complaint chapter, my lord. The chapter is 16, my lord, in BNSS. Earlier it was chapter 15. So now, your lordship, so far as your lordship, whether the BNSS would apply or the CRPC would apply, that is now well settled by bench in your lordship, sumoto matter versus state of AP, your lordship. Therein the division bench was in perfect agreement with the view taken by the Allahabad High Court. I will come to that again, your lordship. I will come to the procedural aspect which has been dealt by the Supreme Court and by the Kerala High Court. What will be the procedure in this case? So first, I will, your lordship, I would like to refer whether the BNSS would apply or the CRPC would apply, because the alleged offense was alleged to be committed prior to the implementation of the new BNSS, but the charge sheet was filed post commencement, madam. So now, which procedural law would apply? And your lordship, we have to second part is, your lordship, we have to verify the date also. So now, your lordship, may kindly come to this judgment of our Guwahati High Court 2024-5 GLT 756. Your lordship, may kindly come to para 19, my lord. Para 19, my lord.
Yes.
May I read, my lord?
Yes.
After taking into consideration the decision rendered by the Honorable Supreme Court and Hitendra Vishnu Thakur Supra and Nena Aneja Supra, the division bench of the Allahabad High Court held as follows. 14. From the above discussed case, the following legal position is called out: that the amended repeal procedural law will be applicable retrospectively unless otherwise provided in the law act itself. The liability or right accrued under the repeal act will not be affected, and same will continue as it is the repealing act and did not come into force. 3. Procedure of investigation, trial, revision, and appeal, as well as a forum of remedy, is a part of procedural law, and the same will be applicable retrospectively unless otherwise provided in the new procedural law. Litigants have no vested in procedural law, but have vested right in substantive law with accrued right of or liability. The statute, which not only change the procedure but also create new rights and liability, shall be construed to be prospective in nature unless otherwise provided. 15. From the above analysis, it is clear that if any offense is committed prior to the enforcement of the new criminal law, then the FIR is registered after the enforcement of new criminal law, then the same will be registered under the provision of IPC in the view of Article 20 of the Constitution of India, but the procedure for the investigation will be BNSS. Similarly, in case of the offense is committed after the enforcement of new criminal law and thereafter the FIR is registered, then the investigation would be conducted as per BNSS. However, in the case the offense is committed prior to the enforcement of Service Headquarter UP is absolutely correct. On the basis of the above analysis, this court is also summarizing the law regarding effect of repealing the IPC and CRPC, BNS and BNSS respectively, and same is being mentioned as below. If now, your lordship, this is important. If an FIR is registered on or after 1/7/2024 for the offense committed prior to 1/7/2024, then FIR would be registered under the provision of IPC, but the investigation will continue as per BNSS. In the pending investigation on 1/7/2024, on the date of commencement of new criminal law, investigation will continue as per the CRPC till the cognizance is taken on the police report, and if any direction for further investigation by the competent court, then same will be continue as per CRPC. Now here, your lordship, you speak about further investigation. If further investigation comes, then CRPC. Now, third part, my lord. The cognizance on the pending investigation on or after 1/7/2024 would be taken as per the BNSS, and all the subsequent proceeding, including inquiry, trial, or appeal, would be conducted as per the procedure of BNSS. Now, in this case, this Roman 3 will come, your lordship, because investigation is completed. There is no any question of further investigation. So now, your lordship, so far as cognizance is concerned, it has to be as per the BNSS. The section of BNSS save only pending investigation, trial, appeal, application, and inquiry. Therefore, if any trial, appeal, revision, or application is commenced after 1/7/24, the same will be proceeded as per the procedure of BNSS. The pending trial on 1/7/2024, if concluded on or after 1/7/2024, then appeal or revision against the judgment passed in such a trial will be as per BNSS. However, if any application is filed in appeal which was pending on so and so, then the procedure of CRPC will apply. If a criminal proceeding or charge sheet is challenged before the High Court on or after so and so, where the investigation was conducted as per CRPC, then same will be filed under so and so, so and so. Now, Your Lordship, 20, we are in perfect agreement with the view expressed by the division bench of Allahabad High Court in Dipu Supra. Now, Your Lordship, the division bench has endorsed the finding and the guidelines laid down by the Allahabad High Court. Here, Your Lordship, it says, if investigation is completed prior to the, Your Lordship, coming into force of the new court, then CRPC will come. But post, Your Lordship, commencement of the Sanhita, then BNSS. Now here, the second aspect would be, here initial charge sheet was filed, no doubt, final report, but it has been converted to complaint because of section 2H of the BNSS, my lord. The explanation which provided that during the course of investigation of a cognizable offense, an investigation is if completed and the offense is non-cognizable one, then it will be converted into complaint, wherein the investigation officer will become a de facto complainant. So when it says complainant, then, Your Lordship, the chapter 16 would apply, my lord, of the BNSS, Your Lordship. Now, the BNSS provision, which my brother has already read, there was no any proviso or giving opportunity prior to the cognizance. So now, Your Lordship, we have to understand when the cognizance part will be affected, Your Lordship. When there is a slight, Your Lordship, distinction, Your Lordship, the part of the cognizance one, Your Lordship. Initially, Your Lordship, the complainant and the witnesses will apply. And for the purpose of taking cognizance also, Your Lordship, there is no any requirement of examine all the witnesses also. It can be examined later also. But here in this case, Your Lordship, the complainant was now the de facto complainant, IO now, who has charge sheeted him under non-cognizable offense. And his witnesses would be the informant, earlier informant, who filed the FIR. So now, for the purpose of taking cognizance, the court, what court can do? The court can record their statement on oath. And before taking complainant from bringing vexatious and frivolous complaint against the accused person. This was the intention of the legislature, my lord. So now, Your Lordship, I will come to the, so the application of the BNSS, it is clear. But now, Your Lordship, so far as, Your Lordship, the complaint part, the opportunity part, that has been dealt by the Supreme Court in Kushal Kumar Agarwal, Your Lordship. In PMLA also, Your Lordship, it has been held that it will apply, Your Lordship. Reported in 2000 SCC online SC 1221. Para 4.
Yes.
Section, my lord, 223 is the examination of complainant, my lord. This is for complaint case. Section 223 of the BNSS, correspondent to section 200 of the Criminal Procedure Code 1973, herein refer as the CRPC. However, a proviso similar to the proviso to subsection 1 of the section 223 does not find place in section 200 of the CRPC. Now 5, this court has taken a consistent view that a complaint filed by the enforcement director under section 44(1) subclause B of the PMLA will be governed by the 200 to 204 of the CRPC. This view has been taken by this court in case of Yes Tuteja versus Union of India and Tarsem Lal versus Enforcement Director. Therefore, the provisions of the chapter 16 containing section 223 to 226 will also apply to the complaint under section 44 of the PMLA as the complaint has been filed after 1st July 2024. Section 223 of the BNSS will apply to the present complaint. The proviso to subsection 1 of the 223 puts an embargo on the power to take cognizance by providing that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. 7. In this case, admittedly, an opportunity of being was not given by the learned special judge to the appellant before taking cognizance of the offense on the complaint. Only on that ground, the impugn order that so and so will have to be set aside. So, meaning thereby, Your Lordship, this proviso is mandatory, my Lord. And now, Your Lordship, the procedure, what procedure will has to be followed, Your Lordship, to issuing notice, summon, Your Lordship. At what stage, Your Lordship? That has been delineated by the Kerala High Court recently, Your Lordship, reported in 2025 SCC, online Kerala 532.
This is regarding
Your Lordship, the procedure for issuing summon to the accused prior to the cognizant order. Here, procedure has been given. So, my Lord may directly come to page number 7, para 7, my Lord. I am on, my Lord, legal aspect. I am not, I don't know about the merit. I'm on legal aspect. What will be the procedure? Because law involved here. So, my Lord, para 7. May I read, my Lord?
Yes.
Indeed, a judicial change in procedure is brought about by the proviso to section 223(1) of BNSS. Pertinently, in spite of the proviso to section 223(1) making it mandatory to provide opportunity of hearing to the accused before taking cognizance, section 226 does not reckon the accused objection at the stage of taking cognizance as a relevant factor for dismissing the complaint. Being guided by the precedent on section 200 and 202 of the code and the plain language proviso to section 223(1) of the BNSS, this court of the opinion that after the complaint is filed, the magistrate should first examine the complainant and witness on oath, and thereafter, if magistrate proceed to take cognizance of the offense, opportunity of hearing should be afforded to the accused. I am also in complete agreement with the following procedure drill delineated by the High Court of Karnataka in Basangauda case Supra. To steer clean the obfuscation, it is necessary to notice the language deployed therein. The magistrate, while taking cognizance of an offense, should have with him the statement on oath of the complainant. And if any witnesses are present, their statement, the taking of cognizance under 223 of the BNSS would come after the recording of the sworn statement. At that juncture, a notice is required to be sent to the accused as the proviso mandate grant of an opportunity of being heard. Therefore, the procedural drill would be this way. A complaint in present before the magistrate under section 223 of the BNSS. On presentation of the complaint, it would be duty of the magistrate concerned court to examine the complainant on oath, which would be his sworn, and examine the witness present if any, and the substance of the such examination should be reduced into writing. The question of taking of cognizance would not arise at this juncture. The magistrate has to, in terms of the proviso, issue a notice to the accused who is given an opportunity of being heard. Therefore, notice shall be issued to an accused at the stage, and after hearing the accused, take cognizance and regulate the proceeding thereafter. 8. In the result, the criminal mis case is allowed in the impugn order that so and so it was. The court below is directed to examine the complainant and his witnesses, if any, upon the accused, though issued with notice from the court below, shall be afforded opportunity of hearing if the magistrate decide to take cognizance of the offense mentioned in the complaint after examination. Having found that the notice could not have been issued to the prospective accused before taking cognizance, notice to respond number so and so in this criminal miscellaneous case is dispensed with, your lordship. So here, your lordship, the procedure is very clear. And your lordship, why the examination of all witnesses is required, your lordship? I'm just giving stress to that because, your lordship, the Supreme Court has held that the complaint cannot be dismissed without examining all the witnesses, my lord. Before examining the witnesses, the court must record the statement of the all other witnesses. Otherwise, the court is the complainant. So here in this case, your lordship, the date I have to confirm, your lordship, whether 31 itself the charge sheet was filed or not. But otherwise, your lordship, so far as the procedure part is concerned, your lordship, there is a procedure error regarding, your lordship, the opportunity to the accused. So at this stage, my lord, what my humble prayer would be, your lordship, may call for the record so as to ascertain the date, my lord.
Okay. This is on knowledge.
Yes, your lordship.
Registered. The Thungar. Land Council for the petitioner. the petitioner filed this. The Court of Chief Judicial Magistrate. (324/34) IPC. The gravames of the petitioner is that by the impugn order dated 28/3/2025, the magistrate has taken cognizance of the offense under section 322(3) of opportunity has to be given under provision under section.
First proviso to subsection
Ah.
1 of 220, section 223.
As per the first provision to subsection
1 of section 223.
1 of section 223
BNSS.
of BNSS, BNSS. Staff of that. Issue notice. Since Mr. Delegated, an additional PP accept notice on behalf of the state respondent. No for and the register proceed lady, as well as by usual process of staff. Then, issue notice, call for the trial court record. This is a scan copy.
Yes, my lord, it's sent
Call for the scanned copy of the trial court record. Okay. Then notice. So then since we are calling for the record, no need to obtain instruction, that's right.
Yes, my lord, because your lordship, now the procedure part has not been complied. So now your lordship, the proceeding has to be stayed. Otherwise, your lordship,
Yes, yes. No, that
it will be
no,
futile
what I'm
exercise.
saying- What I'm saying
Yes.
is since we are calling the record itself, record that you need to obtain instruction.
No, 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 no,
Okay,
not
then,
required, my lord.
Okay. In the meantime, where is your interim prayer?
If we pray, page number
The further proceeding
13.
of in GR case number 25/24 under section 324/34 of IPC, hidden bracket state versus state of AP versus Tumgejini and 2 others shall remain state till the next date of listing. Okay, till the returnable date. Okay.
Yes, my lord, here, your lordship, the state, we are in fact appearing for the IO, but your lordship, let them implement the IO in person also, my lord, because now he's a de facto complainant.
IO
IO is now the de facto complainant in this case. So no doubt, your
But he
lordship,
is challenging the
we,
procedure.
we are appearing for the state. So your lordship, no doubt, we will appear for the state as a whole, your lordship. Let them implement the IO as a one of the
IO
party
is
also,
a
because now he's a complainant. Let them file an appropriate application for implement also, your lordship, the complainant.
Can you implement? Okay. Mr. Pongon, then counsel for the petitioner, praise for allowing him to implement the IO of the case as a respondent.
Yes.
Party. Okay, the prayer is allowed.
my lord, when as and when they file the IA for implement, your lordship. Let the record.
In the meantime, you filed.
Yes, sir.
Okay, in the meantime, okay, so the petitioner shall file an application for implement of the IO within a week from today. Okay.
Yes, sir. Your lordship, after 3 weeks, my lord, for the main case. For the record, my lord.
For the record.
Yes, your lordship.
List, what did I say? List this matter after 3 weeks.
3 weeks, my lord. Obliged, my lord.
This is heavy.
My lord, here in the petition, I have detected two wrong, two mistakenly, they have written instead of Riram, they have written Riba in two occasions. So that can be corrected after the hearing of the case. But there is no any problem about the content and paragraphs, nothing to be changed. The fact of the case is that on 21/7/2025, then FIR was lodged at
Anticipatory bail.
Huh?
You're seeking for anticipatory. It is for anticipatory bail. Pre-arrest bail.
Yes, pre-arrest bail.
Okay.
Yes.
What is the offense registered against you?
Against is section 69 of BNS and section 318 subsection 2 of the
What is this?
BNS.
Okay, 69.
69. 69 is sexual intercourse by employing deceitful means. However, by deceitful means or by making promise to a woman without any intention of fulfilling the same, has sexual intercourse with her, such sexual intercourse not amounting to the offense of rape, shall be furnished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Now, another is section 318. 318.
That is valuable.
That is cheating. Cheating 318(2). Whenever she shall be punished with imprisonment of either description for a term which may extend to 3 years or with fine or with both. Now, this 318 subsection 2 is not applicable here in the case. There are two ingredients. One is fraudulent and one is dishonest intention. And after going through the content of the FIR, it is clearly seen that this section 318 is also not applicable. And this 69 is also seems to be premature. He never says when I left her. She never left. When I married with some other person. Still, the relation is exists. Still, our relation is still exists. And now, even in the FIR, she has also clearly mentioned, particularly in the para 5, that it is true that on 11 June 2025, when he came to my village, Bagra, in the month of June 2025, the present accused has visited to Bagra village and an inverter with a battery 2025, I'm continuing and keeping the relation. Now, what happened? Why this appeal was closed? On 9, the complainant came to Teju. And on 10, the accused father was also reached at Teju. But on
What-
11,
What is the corresponding section to the 69?
Lordship, this is a new law, Lordship.
Hmm?
Yes, this is the new law, Lordship.
69 is new,
Yes, Lordship.
new inserted.
Yes, newly inserted in BNSS, Lordship.
Where do we find?
Oh, Lordship, in the
In
manual,
BNS. Which may extend to 10 years.
yes, may extensively.
Yes, but it appears the case, the 69, section 69 attract it from the allegation.
yes, there is allegation, but it is premature because till to the 9/7 we met, and now on 11 I was sent to Lower Dibang Valley Lowing to maintain law and order because of the mob lynching inside the police station. So till from 11 to 15, I was at Roy. I returned to Teju on 16. So she came on 9 and we left the road.
Now the allegation against you is that you are having another. You are with another girl, another woman.
But that is only girlfriend. Girlfriend means she's a young boy, young person. Why not? Happen to every young man. Because they are young and they are not living in the same as a wife and husband. So this is not an offense also. And I never say that I love you, I'll not marry you. There is no such thing. And still,
This is what the allegation says.
that is the allegation. So my contention is that in the month of June, I have visited Bagra.
So now,
I have gifted the.
have you given? Okay, you are yet to give a statement before the police. This statement.
So my contention is that here in the case is that because of such allegation, when a case is registered, if he would be arrested, the problem is that there will be consequential effect in entirety of his service career. Though the
While in service, involved in so
though
many-
the matter can be settled amicably, Now,
See,
I am a police
It's his own
constable.
creation, it's his own creation. He has
No,
decided this.
I am a
situation.
police constable. I am working under the control and command of the superintendent of police. So where I'll never be caught, nor I'll
Since
be.
2021, you should have married by now. If you have a clear intention of marrying her, and then she says that you kept relationship with her and you no intention to marry. Because of that, you have prolonging.
Yeah. Had I not have any intention to marry her, then why I should offer inverter and battery at their house in 2025 in the month of June? Even I have offered, as a son-in-law, I offered 200 CFT of timber for construction of their house. We could have been married since long back because she was taking shelter. She is refused to marry because their house is under construction. For the purpose of construction of the house, I have given 200 CFT of timber from New Decca.
When?
That is in
Earlier.
I mean, in para 7. In para 7 of my petition, I have written. That the applicant back to state that in construction dwelling house of Alex victim, the accused as son-in-law contributed 200
This is
cubic
from
CFT.
2023, but now
within-
she is alleging now. 2023, their relationship was still good.
Para 9. That the applicant back to state that after completion of the marriage ceremony of younger brother in month of December 2024, accused and Alex victim were together in the house of Alex accused at New Decca. Thereafter, she was taken to the house of the accused, Alex accused.
See, your brother, younger brother also already married. You are prolonging and indulging with another.
And thereafter, I propose.
Okay, so
Lordship, it is not no doubt that they are in relation, Lordship. But situation was after 9th of this Lordship, 9th of this
Nine-
Lordship.
9/7.
When one new girl in the quarter of this accused Lordship. So in
yes, he even made telephone.
page number
also.
page number 22 Lordship, para 6 Lordship in the FIR Lordship.
Okay.
So this is the Lordship city may be called for.
Well, heard Mr. M. Party, Lane Senior Counsel, assisted by Mr. Hmm. Here, the Lane Counsel for the petitioner. The accused applicant filed this application under section 482 of the Bharatiya Nyaya of BNSS Act 2023, seeking grant of arrest bail, apprehending his arrest in connection with WPS Alo case number 07/2025 under section 69/318 within bracket 2 bracket close BNS Act 2023. Start. The informant since 2001. Since the year 2001 to till date, and it is still continuing, and their relationship is still continuing. You intend to marry? Hmm?
Will marry.
Okay. And he has an intention to marry with.
Para
woman.
16 of my petition.
Intention to marry with.
Para 16 of my petition. Appellant accused has not left the alleged victim, nor broke his promise.
And has not yet broken his promise to marry. The information on misunderstanding that occurred on 9/7/2025. The informant has lodged a present FIR. And since their relation is still persisting, and he has not broken his promise, the FIR is the lodging of FIR by the informant is premature. The accused applicant is ready to cooperate with the investigation of the case. No. By the police and cause unnecessary harassment. Hence this application for granting of pre-arrest care. Issue notice. Call for the scanned copy of the case diary or the case diary. He has also been made as a party.
Yes, Lordship.
Okay, since Mr. Lloyd, learned PP, accept notice on behalf of the state, no formal notice need be issued. However, the petitioner shall take steps upon the respondent number 2 by a registered post with AD, as well as by process within 3 days from today. List this matter again.
Second week of August, Lordship. Any date, Lordship. And be it on fifth, Lordship.
Fifth.
Yes, Lordship.
Okay. Good. So if we can get the scan copy.
Yes, Lordship.
Okay. This is matter again on 5 August. Start. In the meantime, in the event of the accused applicant. What is his name? Yamo Riba.
It should be Ruram. We will
It should
correct
be?
it. It's Ruram. As per, it should be Ruram.
Will grant
Yes.
to Riba only.
We will correct it.
No, it is not yet corrected.
No, in
Will
prayer
grant to
person,
Riba only, not to Riba.
in prayer person we have written correctly. That may be right.
You correct it.
Yes, we will correct.
Riba. Yamura, YAM, Riba is in the event of accused applicant Yamurira Rira being arrested. He shall be released on interim anticipatory bail on execution of a bail bond of rupees 20,000 with one surety of like amount to the satisfaction of the arresting authority on the condition with further condition that he shall cooperate and appear before the eye of the case as in when called for, and that he shall not hamper shall not directly or indirectly influence the evidence, influence the witness of the case in any manner. This is matter. Again on fifth.
We may be allowed to correct it. Make necessary correction for
Okay.
correction.
The petitioner is allowed to correct the typographical error in the name, where?
No,
Only name,
yes, name, only name.
name of the applicant. Okay. Declarable. But, if we can by filing, an amended application. Okay. Yes.
My Lordship. Lordship, this present petition has been filed under section 528 of BNS. Lordship, here the petitioner is the alleged accused person, filed in the case filed by the respondent number 2, Your Lordship.
Respondent number?
Respondent number 2, Your Lordship.
Okay, this is the application for?
We are challenging an order which has been passed by the learned Chief Judicial Magistrate Pasigat. I have been aggrieved. Order dated 8/7/2025, Your Lordship.
Okay, what is the problem?
Your Lordship, in this case, the respondent has filed a case against me.
What is the
Whereby-
problem giving voice sample?
For example, Lordship, I have not been received any notice before filing of the application. before
What
the
you will do
Chief
if
Judicial
you, what you are going to do if you receive notice then?
Lordship, I have
What could have you done?
in the
Because it's only the IO made an application before the land court, praying for allowing him to record the voice sample
Yes, Your Lordship.
of following person, including of course you.
Lordship, since I have not getting opportunity to be heard before the learned.
No, what I'm saying is
Yes,
this
Your
is during investigation only.
Yes. Your Lordship.
During investigation, what opportunity is to be given to you for recording? Supposing for the statement,
Yes, Your Lordship.
whether you should be given opportunity,
Yes,
should I record your statement or not?
yes, Your Lordship.
Straight away during investigation, the IO has a power and authority to record. Here in this case, since the IO is going to record your voice sample,
Yes,
including others, who is at least to have, of course, the
yes, Your Lordship.
interaction in the telephone,
Uh,
and made a prayer before the court allowed it. What is the problem?
Yes, Lordship, what happens in this case, Your Lordship, I have also filed an FIR against the complainant here.
That was registered.
That was not registered yet.
Then you take further steps, make an application before before SP.
Your Lordship, it my like humble submission that if I give a voice sample, then it would be tampering and sample and subsequently
How-
used
how?
against me.
That means you are doubting the IO of the case.
And also, Your Lordship, in the notice, my name is not been reflected, which
What
has been
notice?
received from the IO, the BTMS.
What notice?
In
For
page
recording
number
your
17.
statement?
Yes, Your Lordship.
You were called.
Yes.
Whether your statement already recorded by the IO of the case?
Yes, Lordship.
Yes, then you have already given a statement
Yes.
that is no longer here. But then here you are objecting the collection of the voice sample.
Yes, Your Lordship.
What is the problem? There are three others. They are not resisting. They will give their voice sample.
Your Lordship.
So that will be treated that it is your voice only, since you are not ready to give the voice. That will be treated like that only, and you want that to you want that conclusion to be drawn by the eye of the case, that since you are not ready to give your voice sample, it was your voice. You give your voice sample. It's only a recording of the voice sample only, nothing else.
Okay.
Whether their voice at least to have been recorded by the informant was voice or not.
Yes,
They
Your
have sent
Lordship.
it to the FSR. What is the problem? And then another thing, you see, this is in the during the investigation stage.
Yes, it is in the stage of
We cannot
investigation. Your
see,
Lordship.
this is part of the part of investigation only.
Yes.
We cannot interfere with if they have a right.
Yes.
And if we say that not to record, then how will they find out? There is the only way how to find out whether this voice belongs to you or not. That is the only way to find out. And if we stop, then that amounts to stopping the police to investigate the case. It's only recording the voice only. I think this will not harm you. Of course, have a doubt against the eye of the case, you will manipulate all those allegations. If that is there, then that is, of course, different case. If that is not there, it's a part of investigation only. What do you say?
Lordship has rightly pointed out that the
Telephonically threaten or whatever have said. This is the only one. They wanted to confirm it.
Yes.
And if we stop means that
Yes.
amounts to interference.
Yes, Lordship.
So should I dismiss or you want to withdraw? Dismissal will go against you. If you want to dismiss or dispose of, I'll pass order. And if you want to withdraw, I'll allow you also.
Even I may be allowed to withdraw the
Hmm.
with the liberty to file fresh.
Miss Nimcha Hong, Land Council for the petitioner, who wants to withdraw this criminal petition. Mr. Lawyer, Lanet EP has no objection. So, in view of the above, this criminal petition is dismissed on withdrawal of. Deeply obliged.
May I please, your lordship?
Yes,
Lordship is the same petition with the necessary correction.
same petition.
Yes, yesterday.
Oh, yesterday.
Yes, I made.
Okay, so now you have mentioned the
GR.
case number,
Yes.
which you wanted to be
Yes.
what? Otherwise, you say, unless there is a prayer, you cannot go beyond.
Yes.
Okay, Mr.
PC guy.
P. Siga, Land Council for the petition. Will issue notice.
Yes,
You have anything, sir?
actually,
I think joint petition.
yes.
We'll just call
Case of
for,
extortion.
call for the, it is still under investigation.
No,
No.
under
Oh, sorry.
sorry, evidence.
Charge framed.
Charge frame.
Yes, yes, that is why. What is the offense? Let us.
Abridging human mercy,
IPC
Yes.
392.
392 extortion.
Okay, okay.
It's robbery, Your Honor.
Figure. Okay, robbery.
Sorry, robbery.
Land Council for the petitioner. Para. This is an application filed by the petitioners under section 528 of Bharatiya Nagrik Suraksha Sanhita 2023. Praying for passing and setting aside of proceeding in GR case number 480/2015 arising out of the ETA WPS case number 73/15 under section 47/354/392/201/323 IPC pending before the Court of the Chief Judicial Magistrate, UPI. The petitioner number 1, Srimati Kekhomgi, is the informant, and the petitioner number 2, Sri Gichik Tang, is the accused in the above GR case number 480/2015. Stop. Back. Just a minute. Okay, issue notice. Returnable by 4 weeks.
Yes,
Stop, Mr. Since the land addition of PP accepted notice on behalf of the state.
this year.
Trial court record in GR case number, a record of GR case number 480/2015. And 2015, Court of the Chief Judicial Magistrate, UPI. Staff. Last, list this matter. after. Oh,
Yes.
it's three, okay, then make it 3 weeks, after 3 weeks, okay.
Oblación.
Obligations.
May
Just
I
a minute.
please, Your Lordship?
Just a minute, huh? Okay.
May I please, Your Lordship? Your
Yes.
Lordship, this is an application under 482, Your Lordship, whereby we have prayed for quashing and setting aside the order of dated 30/8/2023 passed by the learned Chief Justice Magistrate Bomleda in CR case number 8 of 2017, Your Lordship. And also with a prayer that allowing the petitioner to adduce his defense witness in the same matter, Your Lordship. In the same matter, already we have taken on various occasions, we have taken steps, Your Lordship, but none of the respondent has not turned up, Your Lordship. In
Service report is still awaited.
Yes, Your Lordship.
Who are these respondents?
Your Lordship, it's a company, Your Lordship. It's TL Construction, Your Lordship, which is situated in their office is at West Khameng, Arunachal Pradesh, Your Lordship, in the under police station of Bhalukpum, Your Lordship. I may be allowed to state one more thing that, Your Lordship, in the IA, Your Lordship, in this matter, a dusty service has also been taken in this said matter, Your Lordship. But even after that also, sorry, I'm unable to hear you.
Okay, yes. You take fresh
But-
steps.
Yes, Your Lordship. Your Lordship, in the IA, an interim order was there, so that may be continued, Your Lordship.
Steps was taken long back in the month of April.
Yes, Your Lordship. Through registered court as well as through the to the learned court of Chief Judicial Magistrate Bomleda, Your Lordship.
Take fresh steps, okay?
Yes, Your Lordship.
Okay. In view of the is not dated. Eleven to 2025. One 3/2025. The advocate is Ndeka.
Yes, Your Lordship.
Okay. Miss Ndeka, Land Counsel for the petitioner. Praise for allowing her.
Your Lordship, if possible, a date may be fixed, Your Lordship.
By a registered post with AD as well as by a dusty service is also allowed, in which case the petitioner shall file compliance affidavit. This is matter after 3 weeks.
Your Lordship, a date may be fixed, Your Lordship. Because in the last occasion, because of the date was not set to.
May I, Lordship? Lordship, this is a joint petition filed by the petitioner number 1 to 5, here for quashing of an FIR dated 5/7 of 2008, Lordship.
Joint petition.
Yes, Lordship, this is a joint petition.
If I reject,
Page 24 is a type copy, Lordship. The page 22 is the original photocopy, but since it's illegible, 24 is the type copy. May I read, Lordship?
yeah,
To the circle officer Dune. In favorable necessary action, please. That I am a student of class so and so, studying at government higher secondary school so and hailing from so and so village under the Dune administration. My father name is so and so. Sir, I am to inform you that yesterday on 4/7 of 2008, I was going back to my home with my cousin sister and some of my friends after the school was over at 3:30 p.m. While we were approaching towards home near EPS oil station and around 4 p.m. There appeared before us all of a sudden a 4-person, that is Changla or so and so, they are the petitioner and one unknown in the Maruti car. To my utter surprise, one of them, namely so and so, that is petitioner number 2, son of so and so, shouted to his companion, pointing towards me, "This is the girl, catch her." And they rushed towards me and hold me. I cried and tried my best to make myself free from them. My cousin and so on tried their best, but in vain. They forcefully put me in the car and took me to one's Sri so and so resident in our village. I was kept in room and locked with the woman of the house for about 45 minutes. It says only 45 minutes. Unfortunately, one of the window found to be open. I managed to escape through it. Coincidentally, my
what
uncle.
was her age?
At that point of time, she was 16 years old.
Okay, what was the age of these accused persons?
Accused Lordship, at that point of time, he was he had graduated. After graduation, he was 27, Lordship.
42 years, 31 years, 54.
No, at that point of time, Lordship, he was 27 years. 27 years, the petition number 1, the one who.
44, 48. See, kidnapping the small child.
No, Lordship, at that point of time, I'm saying, Lordship, now.
Registered, offense registered?
366, it's kidnapping, Lordship.
366.
Lordship, that was in year 2008 when the incident had happened. The petitioner number 2, who is the, he was 27 years old. Now.
Let us see the agreement, what it says.
Agreement, Lordship. The agreement, Lordship, deed of settlement is page 104.
What is the present position of the victim?
Victim, Lordship, now she is working as a nurse. And she is working as a nurse.
Okay. Now.
And they're living their own life, Lordship. Everyone is like, Lordship, before this.
She is married?
She is not married, Lordship. They belong from a Kamti community, Lordship. What is happening? So he wanted to marry her.
That custom was prevailing.
Yes, Lordship.
That has to go. That has to go.
That's why, Lordship, they say
that has to go.
that doesn't.
Now you see that.
Complaint against him. The compromise is
that,
page 04, Lordship. This of compromise is made on 28th and so and so to the I so and so, Lordship. They said, Lordship.
What is her age now? Has she said no?
She is of age now.
Not given.
31 years. She's now
31 years.
31 years.
Yes.
My lord, prosecution witness already completed. Now stage of 313.
Oh,
and
trial completed.
Trial almost completed, your lordship.
Okay.
And now your lordship is very aware, your lordship, the Gyansing, what Gyansing says. If there is a remote and bleak chance of conviction, but here is a case, there is a full chance of conviction, man.
Okay.
Your lordship will kindly see page number 96, the statement of the victim.
Okay. Page
96, my lord. The deposition of the victim. It's intake, man. while I was along with my sister was returning from the school, the accused person is standing on the dock forcibly took me how they are waking not, your lordship. That has to be looked into. If it was prior to the commencement of the trial, your lordship, then it can be presumed that there is a remote and bleak chance of conviction. But now at this stage, your lordship, the evidence is intact, man. And kidnapping is against the society.
So the eyewitness also stated the same.
This,
Yes,
Lordship may kindly appreciate, Lordship, the town which it's a small town, Lordship, now she's unmarried. Lordship, in eventuality of Lordship, just not assuming for a moment, if they are convicted, it will be a talk of town also, Lordship, and it will be maybe because of that, for seeing her future. She's of 21 years age and she's maybe because of that only, Lordship, they have come to a compromise. In this also, Lordship, they have stated that she doesn't want the other to be punished for a custom which was prevailing in their society. So, Lordship, this inherent power of Honorable Court can do, Lordship, even if the trial has come to an end, Lordship. Lordship,
Standing now at this moment, they have to satisfy the court the peculiar circumstances. Otherwise, this is not a peculiar circumstance; it's a normal.
See, yes, as per the evidence, there is material against the accused.
Yes.
They have not been demolished.
And Gyan Singh will not apply in this case, madam.
Yes, it appears. This was recorded, evidence was recorded when it was 23.
And also the trial has been stayed, your lordship. That is why it's not progressing.
It was a state.
Yes, your lordship, by this honorable. So that's why it is not progressing, your lordship.
trial was, the statement was taken on 24th day of August 2023, Lordship. Lordship, the uncle who had made the, who took the victim or the petitioner number 1, may Lordship kindly appreciate that also. In oath before the court also, they have said they have settled the matter way back, Lordship.
Page
Page 99, Lordship.
99 is the
Statement of the.
he stated my daughter.
Yes, Lordship. What they I may I did on oath. I recognize all the accused except one who is in pink color t-shirt. I'm paternal uncle of so and so.
Okay.
One day my daughter so and so came to me crying at 3 p.m. and told me that my
Yes,
daughter so and so was forcibly taken by the accused person staying on the door. I accordingly went out in search of my daughter at in no village and shouting her name. While doing so, my victim daughter heard me and came out of the house where she kept and honor of the house where my victim was kept in so and so. I accordingly took my daughter to house. My statement was not recorded by the police. He says, in cross lots, what he says, whatever I said before this court today is based on the information given to me by daughter so and so. We had already settled this matter outside the court. Meaning the lordship, because of ignorance of law, Your Honor, they have not appeared before the honorable court, before the trial of the court. But lordship, from here also it says that the matter has been settled way back outside of in their agreement also not in
maybe, but then
deed of
you could have actually
in the deed of
I think you will have in 313
yes,
on given opportunity you can give that statement that it was because of the customs we did that, and then thereafter nothing happened and the matter has also been settled. because it was only trial as per the customs. Better give that statement before the court. And then if you agree, probably because we are what we could see is, although we want, but then because the law doesn't permit, that is only that. And then once you said in your 313 statement that there was a custom, and because of that, and they are also not agreed now, and case settled. So I think after that, what the court decides, you can come back here.
Yes.
That will be better, because now under the circumstances, given this evidence, this court is helpless to interfere with.
Lordship, under inherent power of this honorable court, Lordship, in the
Maybe, but then you see,
deed of compromise also, Lordship,
power is there, but then here we cannot exercise in your favor. It will be exercised to dismiss your. Difficult for this court to interfere with. Take chance there. Proceed. Let the proceeding proceed in 313. Go prepare. Give this statement. All those, so that the court also justified, and present the settlement copy also, because the girl also, the victim also clearly stated, other than taking her, keeping her there for 45 minutes, there was nothing, and then old women were also there, and probably in your evidence, defense evidence, produce those the all let them also give a statement that according to our customs, it was brought, and we didn't know the age of the girl. And that was the custom at that point of time. We didn't do, and then it was not with a male person, it was with a female, and then we tried, and then subsequently she was taken back, and then that's enough, end of the matter. I think you will be saved. Just follow and complete the procedure.
It's already been recorded.
Yes.
And as your lordship guaranteeing it is held that remote and bleak chance of conviction. Now that part goes.
It's not like,
Only
not
simply
it's
because
not
they have settled the matter will not suffice your lordship
No.
to exercise inherent power.
because that is only after recording of this evidence only you have settled. So this record is still there. How do we discard this? Cannot be. Take that chance. Suggest your client to give proper statement during 313 statement, and also give defense evidence, including the women who were, because they also stated that women were there. Women's two of the women will do that. There were also. I'm giving an idea. So you want this matter to be dismissed? Dismissal will go wrong message, it appears, or what?
Lordship, in that way, I'll adjourn the matter and I'll
Take chance.
take the.
No,
Let this keep this matter pending.
I'll brief them, Lordship, what the honorable.
You take chance. You take chance in 313. Let us see, and there you will also come to know what your client has stated there. How many accused?
There are 4, Lordship.
4 accused, and then from there we can understand. Okay. Who you will be able to measure thereafter, huh? But Mr. V. Jama, counsel for the petitioner. Also had Mr. T.A.T. and an additional PP. This is This is item
12.
12. Okay, in admission. Mr. Jamo, praise for adjournment of the matter. For 4 weeks.
2 weeks will do, Lordship.
2 weeks.
Yeah.
2 weeks, this code will be there. The same result.
No, Lordship, if I'll inform them, I'll take to let them.
Okay, give
I'll-
that suggestion, yes. That way, if you
That
want.
way, I'll give them suggestion and I'll withdraw it on the next day.
Oh, that will be better.
Yes.
Because only the procedure,
Yeah.
you have to convince them that only the procedure is to be complete. Otherwise, it's going to be the positive result. Given that, of course, only in the 313, you have to give proper statement, and along with the accused persons, 4 of them, and 2 women or 2 or 3 women give statements, nothing will happen, I think. Because they
There
have
must
only-
be something, my lord. There must be something so that your lordship, the court can exercise its power, your lordship.
Yes,
At
then
least.
there will have something.
Yes, sir.
So thereafter, you can present it also. Then we'll have something at least.
Yes, sir.
That there is a remote. Okay. The prayer not objected accordingly. The prayer is allowed. List this matter after 2 weeks.
Yes,
Okay.
Oblige, sir.
Oblige.
In this matter, I have taken step to the private respondent, whether have been complete or not. Private respondent, since victim has already died, he was the person I have.
You have amended the course title also? Amended the course.
This previous respondent, private respondent has already died.
Who the?
That is, and I have included this complainant now.
Informant.
Informant.
Okay. No notice was issued to the informant. Will issue notice?
I think I have taken already steps to the as per
You have
the
taken
direction of
steps?
honorable court. Yes.
There was a direction.
Yes, already.
The sick paying this to needful to implement. No, the last order says that you place
Office
10
notice
days for
silent about
implement.
taking office steps.
Hmm?
Office notice silent about the taking steps.
There is no record.
13 May.
13 May.
Yes.
13 May, there is no order.
Kapalata.
No, 13 May is, okay, 13 May, yes, okay.
Yes.
The latest order should be in the above. No? No, the 13 May is on behalf of the so and so land conducting council for the raise for this. No, this is adjournment only. Okay. Mr. Tapak. Land council for the appellant. Your implement was allowed.
Yes.
Okay. While amended course title by implementing the inserting the newly implemented response number 2. Let a notice be issued to the newly implemented respondent number 2. Stop. The petitioner shall take steps by register post with AD as well as by usual process within a week from today. List this matter after 4 weeks. Okay.
Objection.
Mr. G. Tado, Learned Additional PP. So the state respondent is also present. Okay.
Objection. Yes.
Lordship, I append on behalf of respondent number 1.
Service report in respect of respondent number 2 not received. So
This,
who is respondent number? Are you anyone representing? You are for
I
respondent
for respondent R1.
2. You are for the petition. You are for appellant. You are for respondent number 3. And who is for 2?
I'm for the
No,
petitioner.
you are for the petitioner. So the service report upon the respondent number 2 is still awaited. When did you take steps?
Uh, Your Lordship, I have been instructed to just take time. I'm not-
Okay, you take time, but in the meantime, you take steps also. Okay, it's better because it appears that you have taken a step long back. Otherwise, it will report like this only. Service report is still awaited. You take fresh steps if you want to, if you want this case to be proceeded with. Okay. In view of the office note dated 26/6/2025 and 23/7/2025, the Learned Counsel for the appellant prays for allowing him to take fresh steps upon the respondent number 2. The prayer is allowed. Steps upon the respondent number 2 within a week from by upon the respondent number 2 by a registered post with 80 as well as by usual process within a week from today. Stop. This is matter after 3 weeks. Okay. One and Mr. T. Tapak. Your name is not appear, Mr. Tapak. Oh yes, it's there. Tapak, Learned Counsel for the respondent number 3 are also present. Okay, this is okay. Obligation. Yes.
Service report upon R2.
Awaited.
Yes.
Upon respondent number,
I'm appearing for respondent 2.
you are appearing for
Yes, respondent number 2.
respondent number 2.
Yes.
Press stay for the service or not. Okay, respondent, you
That means
you are appearing for the first time.
Yes, I'm appearing
Okay.
first and third.
How many respondents? Who is for the petitioner? Behalf of the petitioner on call. The G. Tado, Learned Additional PP is present on behalf of the state respondent and Mr.
M. Dojiman.
Doji
M. Dojiman.
Doji would appear on behalf of the respondent number, a private respondent number 2. You have filed Wakalat Nama.
Yes, I will.
By filing Wakalat Nama. Since the respondent parties appeared, let this matter be listed for admission after 3 weeks.
Yes, call for.
This is what? Criminal petition only.
Yes.
Okay.
charge sheet.
Record was not yet called for. It's there. Since the respondents would appeared and the records has also been received, this will matter for admission after 3 weeks. Okay.
All right.
Yes.
Lordship, today my leading counsel, Mr. D. Tamut, could not be able to attend today's proceeding, Lordship. So, seeking for an adjournment for 3 weeks.
Okay. Just a minute. Huh? Record. Probably after obtaining this stay order,
Yes, Your Lord.
they have been seeking adjournment only. What is this case about? It's a common cause.
It's a section involved is
Okay, joint petition only.
Yes, my lord. Joint
Why they are not appearing?
341 and 324 IPC.
341.
Yes, Your Lord. 341 and 324. 324.
34 is also there.
Yes.
Why they are not appearing? One chance
Yes, Your Lord.
can be given.
Yes.
The next day we'll try.
Yes,
If
Your
they
Lord.
don't appear,
Yes,
we'll
Your Lord.
vacate.
Yes.
Mr.
Il Ngamlai.
Lieutenant Counsel submits that the conducting counsel. Who is the conducting counsel?
Mr. D. Tamut, Lordship.
The Tamut. He is out of the station, therefore pray for adjournment of the matter for 3 weeks, to which Mr. T.A. Learned PP has no objection. Accordingly, the prayer is allowed. This matter after 3 weeks.
Oblige, Your Lord.
This was the scan copy.
Yes, Your Lord.
Okay.
Oblige.
Highly obliged, Lordship.
Okay, I've taken steps on the private.
The state is there. Private respondent. This is, what is this matter about?
Lordship is for quashing of FIR.
Quashing. So joint petition or?
No, merit.
Not joint petition. So then you have to, I think, ensure that the private respondent appear in that case. See, service.
Earlier, address was not found in address. Earlier,
Not found in a given address. You
Yes.
have to identify, I think, then.
You know, this is the correct address. They are deliberately evading the service.
No, how the postal. It says. Respondent number 2 in the forwarding letter mentioned that. Not found in the given address. Okay, you have taken a fresh step thereafter.
Yes.
So it is still awaited. Okay. Mr.
Zika.
But your name is not reflected.
My lord, I've signed the work.
Mr. G. Gatulani, counsel for the petitioner is present. Mr. G. Gatulani, additional PP is also present. The notice of respondent number 2 is still awaited. In view of the above, list this matter after 3 weeks. Stop. The registry shall reflect the name of Mr. G. Gatul as learned counsel for the petitioner. Okay, in the course list.
God bless.
Yes. This is also criminal petition, yes, lordship, for classing all the lost courses. There is a private, no. Petitioners, no private respondent, joint petition, it appears. Record received. Okay. None appears on behalf of the petitioner on call. So where is on call? Where is Mr. Loy? Dana PP is present. So in absence of the petitioner, the matter. Thank you. Well, Mr. Loy, Dana PP is present and staff. The record, the scanned copy of the trial court record has been received. Staff. However, in absence of the petitioner, the matter stand adjourned. This is matter for admission after 3 weeks. Okay. Dear parents.
May I please, Lordship?
Yes.
Lordship, I'm appearing on behalf of Esther, Lordship. Service report is still awaited, Lordship. So I may be allowed to take precedence.
Okay.
Oh, Lordship.
You're for the petitioner
Yes, Lordship.
on behalf of
Esther.
Esther, land counsel for the petitioner. Praise for. No, just a minute. The office note dated 23/7/2025 reflect that the service of notice upon the respondent returned with a postal note within inverted comma, no such person so return to sender, inverted comma, close. In view of the above, Mr. So-and-so, then appearing on behalf of Mr. S. Tai, land counsel for the petitioner, praise for allowing him to take fresh steps upon the respondent after how many respondents?
One, Lordship. Sole respondent.
After identifying the current address of the present address of the respondent. So prayer aloud. Press steps upon the respondent, sole respondent be taken by a registered post with AD as well as by usual process within a week and within 2 weeks from today. You have to identify the proper address of the respondent.
Yes.
That's why I'm giving 2 weeks.
Yes, Lordship.
Please this matter after 4 weeks.
Deeply honest, Lordship.
My lordship, please adjourn this matter, because
You have decided there. Okay.
actually I have already taken the counsel because we need some time to file IA, and the conducting counsel is out
File
of state.
reply.
Yes,
You have received the affidavit.
IA.
Hmm?
IA. I have to file IA.
There is IA also.
Yes,
Item 22.
22. Yes, ma'am.
Where is you need to file IA?
Yes.
For what?
Lordship, for revocation of interim order.
Interim order.
Yes.
Miss.
Yasmin Gao.
Yeah.
Yasmin Gao.
Your name is okay. Yasmin Gao, Land Counsel for the petitioner is present. Miss
M. Jerang.
M. Zerang, Land Counsel for the respondent number.
Respondent number 1.
How many respondents are there?
Lordship, 3 respondents are there.
Okay, respondent number 1 wants to file IA for there is interim order.
Yes, Lordship.
Wants to file a vacation petition against the interim order passed by this court only. Then IA want to file IA for vacation of the interim order passed by this court on 21/5/2025, and according to brief for sometimes the prayer is allowed. Miss this matter after 3
2 weeks. 3
3
weeks. 3 weeks. Obliged, Lordship.
Yes.
May I not?
Yes.
I put a petition.
Okay.
Last occasion, a CD has been pulled.
Oh, is there any other private respondent?
No.
Hmm? What is this petition about? Criminal petition for what?
Respondent number 1.
Who is respondent number 1? Hmm? It's a state.
Matter
You
is,
have not implemented.
matter is already charged sheeted.
Charge sheeted.
Yes.
See, your petition is only the state has been mentioned. No other respondent. If you want, then you probably have to file an application for implement of the informant and the victims as a respondent party. That's it. The record was also called for.
Allegation is 303. Is
Hmm?
port allegation is 303 BNS is port tapped and read with section 3 PDP.
Lordship, since leading counsel is out of session, so matter may be fixed for hearing after 2 weeks.
No, I think you heard Mr.
N Taro.
N.
Taro.
The petitioner is the petitioner is praying for quashing of the FIR number 22/2024 under section 302 of BNS related with section 3 of PDPP Act 1984. However, the informant has not been implemented and had not been made as a respondent party. Therefore, pray for allowing him to impede the informant as a respondent in the present criminal petitions. The prayer is allowed. The petitioner is allowed to file IE for impediment of the respondent as the impediment of the informant as respondent party. So Mr. Dado, then maybe additional people is also present. So list this matter after 3 weeks. You impede them. Otherwise, it cannot proceed. They are to be given notice. Okay. Those who file FIR, you have to impede them, make them as a party. Okay. Yes.
Lordship, on the previous day, the admission hearing.
Okay. Both the Land Council for the petitioner, Mr. E. Pine.
Yes, Lordship.
Sorry. Heard Mr. E. Pine, Land Council for the petitioner, as well as Miss, also heard Miss Hage, Land additional PP. The trial court record as called for has been received. So in view of the above, let this matter be listed for admission after 3 weeks.
3 weeks.
Okay.
Lordship.
Lordship, I forgot to mention the interim order.
What?
Item 22.
What?
In item 22, I forgot to mention interim order.
There is interim order.
Yes, Lordship. That interim order may be continued.
Have I recorded her name?
Yasmin Rao.
Okay. Yasmin Gao, no? Okay.
Yes, Lordship.
Para. It was to be listed after 3 weeks.
Yes, Lordship.
Okay. In the interim order passed earlier shall continue till the next date of listing. Okay. Anything else?
And Lordship, in my item number 24 as well, interim may be continued.
24 also. In 24 also, huh? The interim order passed earlier shall continue till the next date of listing. Okay.